Okay, Mr. Ruiz Caras, you're up.
Thank you, Your Honor. May it please the court, Isaac Ruiz Cruz on behalf of the Property Owners Association. This is a dispute between a property owners association and its neighbors to the north regarding the use of the association's private road, boat ramp, and dock facilities. And there is an agreement that governed the rights of the party, the 1990 agreement. And it's our position that the trial judge below misconstrued that agreement. He did not properly follow rules of construction, and there's some other defects in his reaching what we think are contradictory conclusions. The first is this issue of the agreement and the reading of it being contrary to the basic rules of grammar. And the critical portion of the 1990 agreement is the revocation clause. And the revocation clause says, upon default of payment of any fee as set forth herein, or use of the easement herein granted by Baker in unreasonable or offensive manner, or in a manner inconsistent with the use of common areas by owners of lots within the subdivision, the easement appurtenant shall automatically cease.
But Judge Nielsen, while he may have construed that language in a way that you disagree with, he ultimately said, and even if I'm not right, that the use of the easement as a finding of fact, he was sitting as a trial judge, was not unreasonable or offensive. Doesn't that carry the day here?
No.
He basically, as a finder of the fact, said, I don't have a problem with this.
He didn't actually make that finding, with all due respect, Judge Morris. He didn't find that it was unreasonable, that it wasn't unreasonable or offensive. What he found was that it wasn't outrageous. He didn't apply the proper standard. And that's what our argument was with respect to this even if scenario. So he should have applied, in its de novo review, what he did as far as construing the language of the document. And I fully understand we're getting into the standard of review issue. If he's sitting as a fact finder and he made a finding that even if we were correct about our reading of this revocation clause, you're saying, well, he didn't find the facts that are sufficient to support your argument. And I would suggest he absolutely did, but he applied the wrong standard. So in reviewing this issue, he applied, well, the conduct wasn't outrageous enough. But in reviewing whether or not to award money damages on our trespass count and whether or not to grant injunctive relief for overburdening the easement, he absolutely found conduct that would be sufficient to meet the termination clause if it's read as unreasonable or offensive, or the third part, which is very important, right? Which is, or in a manner inconsistent with the use of common areas by owners of the lots within the subdivision. So it doesn't just have to be unreasonable or offensive. There's a third way that you can have automatic cessation under this revocation clause, and that's if it's used in a manner inconsistent with how other owners of the common area of the subdivision, how they use the common areas. And what he found in supporting his injunction, and I think that that's what's extremely important, he awarded money damages for trespass, and he awarded an injunction, and he specifically found, quote, that the Bakers and Myers, through the creation and use of trust and real estate transfers, expanded the original Baker parcel into a 5-lot subdivision with newly constructed houses. Owners of houses using easement without authorization. That's at P296 of the record. And he specifically found that on that basis of the trust and real estate transfers, and now the owners using the property, using the road, that placed an undue burden on the easement, also at P296. So he found support for injunctive relief and money damages in the conduct that was done here, but he doesn't think that that meets the threshold standard under the revocation clause, and he was using the wrong standard. So I would suggest—
How many houses were built in that Baker subdivision of 5 lots?
So there's several houses. What's that?
Only one was built, right? Lot 3?
Lot 3 was built as a spec home, and that's correct. And then they have the original home that's, then now the Myers live in Lot 3. And then there's still the original home. And then there was, for a time, they were residing in the second home that's also there. So there's a total of 3 habitable structures in those lots during this time frame. Yes,
my point is they platted their property, the Bakers, into 5 lots. And they went to this association meeting and they sort of let it be known that that's what they were going to do. And then there was this uproar over that. They only built 1 lot for themselves, only built 1 house for themselves. And as I understand from reading this case, they've pretty much abandoned any effort to develop any of the remaining lots. Is that right?
Well,
And the reason why this is important, it's important to Judge Nielsen's finding that there was no undue burden placed on this easement by this subdivision, which caused all this problem.
Well, Your Honor, respectfully, he found there was an undue burden on the easement. That's why he granted an injunction. That's what I was citing to at P2. That's what's contradictory about his ruling. He finds that there is an undue burden on the easement. And at this very same time, he finds that, well, I'm not going to read the default clause the way that you read the default clause. I'm not going to find that the Baker Myers can default by any conduct whatsoever. The only way they can default, the way he read the revocation clause, was by non-payment of fees. And he said he was doing that because the title of the document was Grant of Reciprocal Easements. And, you know, Your Honor, I'm sorry, a light bulb went off in my head. Since we're doing a virtual oral argument, I'd like to reserve 5 minutes of time for rebuttal if I could. I jumped right in.
I wrote that down, so I got you covered.
Okay, perfect. Thank you so much. He relied on the title of the document, Grant of Reciprocal Easements, and said, well, because it says reciprocal, then it would be illogical to read the default provision as not also being reciprocal. And I would cite to, as we did in the briefs, Jabor versus Topino, that what title you put on the document is not what carries the day with respect to easements. And in fact, rules of grammar, as we cited to, require that you read this particular revocation clause as giving a right to terminate in the association. But Your Honor, what you're relying on, Judge Morris, is the language from Judge Nielsen's order where he said that even if the default provision is the way the association suggests, then the conduct here is not so outrageous as to warrant the termination of the easement and the placement of the barricade over the roadway, the little opening in the roadway. But in that same order, he finds that there has been an undue burden placed on the easement by the Bakers and the Myers. And what I'm suggesting in our brief is, one, he's applying the wrong standard with respect to his fact finding, and therefore you all can engage in de novo review. But secondly, the very conduct that he found placed an undue burden on the easement, which, by the way, there was a cross appeal, but it was dismissed. So for all intents and purposes, really, and the facts were undisputed, but at this point, we have a finding that has preclusive effect as to the appellees, and that is the finding that there was an undue burden placed on the easement now has preclusive effect.
Well, the difficulty with that is that the undue burden is the platting of these 5 lots. As far as I could tell, it wasn't necessarily the use of the easement. There were a couple of cement trucks that came once or twice in the building of one of the houses. There was a wedding, that's whether it was approved or not approved, that was unresolved in my mind. One side says it was approved, the other side said it wasn't. But I mean, it was this uproar came about not because of the use, because it came about because the Bakers went to this association meeting and said, we've now platted these 5 lots and we're going to use this easement. And that's the only real facts that I could determine that went into the whole dispute.
Well, Your Honor, as you said, there are certain findings that were made by Judge Nielsen in this case. And if we look at the findings he made at P296, and that's the part of the record where he has his order, he specifically makes the finding that not only was there the platting, but that there was also the use by owners of houses within that Baker subdivision without authorization. So
you like that part of the order?
I do, because I think it carries the day, Your Honor, because he cannot reach these 2 conclusions at the same time. I mean, and there's something just fundamentally contradictory here. If he found both use and platting, and just to get back to it, Your Honor, just for the purposes of the facts, at the meeting, it's true, the Myers came as agents of the Bakers, and they said, hey, this is our plan. Here's the plat. Look at what we're going to do. We're going to develop these lots and we're going to build these homes. Now, standing from the standpoint of the association, what are the subsequent acts that occurred? And all these communications are also, by the way, in the record at P961, P962, and those are emails and letters that Mr. Myers, as trustee of the trust for Ms. Baker, was exchanging with the association, where he's making it clear that they are proceeding with their plans to develop those lots. So when the association sees construction trucks coming on their road and going to the property, when the association sees this house being constructed on the lot, and they're receiving communication to say, hey, we're going forward with our development. And the testimony at trial also included the builder for that home. And he indicated that he used the road he used the gate and Winthrop Way, the road, and that he used the Winthrop Way address, which they did not have, for securing building permits, doing natural resources reviews, all the things that are necessary for construction of a home. All of that was use of the easement. And all of that was before Judge Nielsen, and in fact, part of his order when he found that there had been an undue burden placed on the easement. So what I would suggest getting back to it is, and in fact, there's even a concession, and I know we pointed this out in our brief, when we pressed this issue at the trial court below, counsel for the appellees, and it wasn't Mr. Elegant, but counsel for the appellees below made the concession that if there is an undue burden placed on the easement, then there is a right to terminate. And now in the briefs, when I said that's a concession, what the argument was that was made in the answer brief is, no, it's not a concession, it's just a statement of the common law. Well, be it as it may, whether it's a statement of the common law or whether it's a concession, once there's an undue burden placed on the easement, there is a right to terminate that exists. And we know that from longstanding law, the Star Island case that we cited in our briefs from the second DCA, there is suddenly, it gives rise to a right to terminate that the association exercised. And they absolutely exercised that and exercised it correctly and validly. The only basis for the argument that the Bakers have to try to suggest, no, what Judge Nielsen did is correct, is to say the agreement itself, the language of the agreement must be read such that the association never has a right to revoke. The only way they can revoke is if there's a non-payment, which is clearly not the facts of this case. There's been payment of the fees the whole time. That's the only way for them really to win, is to say Judge Nielsen got it right. This agreement, it controls and governs the rights of the parties, and it absolutely requires that the association can, if they behave improperly, then there can be revocation, but the other way can't be. And that's what's at the heart of his argument, and this is why it fails, in addition to the rule of grammar not supporting the argument. This is really the second issue with respect to that, and that is, think about the logic of this. We have a private road, a boat ramp, and dock facilities. Next to it, we have a small concrete pad that's completely covered in shrubs and debris the entire period of time. And yet, the argument is that it's logical to read the revocation clause as if the association uses this concrete pad covered in debris and shrubs in a manner that's unreasonable or offensive, then Baker can revoke. But if Baker uses the road, the dock, or the ramp in a manner that's offensive or unreasonable, then the association can't revoke. That can't possibly be what the parties.
Let me tell you the difficulty I have with that. And it's looking at the plain language of the agreement. And when you read it in context, there are two easements granted by the agreement. There are reciprocal easements granted. And the language says, or use of the easement herein granted by Baker in unreasonable or offensive manner, et cetera, et cetera.
Mhm.
Now, if you say, or use of the easement herein granted, and we accept your argument that by Baker refers to use, well, there are two easements here. So when you've got the provision that says, or use of the easement herein granted, well, again, there are two easements. So which easement are they referring to? I mean, obviously it doesn't mean use of Baker's own easement. I mean, that seems like a ridiculous interpretation, right? That if Baker uses
exactly.
No. If Baker uses the easement that Baker granted to the association in an unreasonable manner, that doesn't make sense.
Well,
so
and this is why we disagree with that position. We think the entire revocation clause is applying to the ramp, the dock facilities, and the road. The entire revocation clause. What's that?
I understand that that's your position, but there are two easements. So which easement are we talking about?
We're talking about.
Why isn't it clear from this paragraph that, and it says, or use of the easement herein? Okay, which easement herein? Because there are two of them. Well, the easement herein granted by Baker. Why is that not a perfectly logical way of reading that provision?
And it's not for the reasons that we suggested. And let me suggest this too. If in fact there is a second reading, and I know you have a concern here that, well, which easement is it? then that suggests that there may be an ambiguity on the face of this document.
I don't disagree, but your
If there is
argument
an
all
ambiguity,
along has been that there's no ambiguity. And in fact, Judge Nielsen even relied on that and put that in his order, that your position all along has been there's no ambiguity.
and to be clear, our position was at the motion for involuntary dismissal at the trial was there is no ambiguity. The way that we're reading it is correct. If he suggests, no, there's two ways to read this, and our construction is absolutely correct under the rules of grammar, and is it a valid way to interpret this document? So if Judge Nielsen's suggesting there's a second way, and that's what I argued in front of him, then he should have permitted parole evidence. And I argued that as I was attempting to put on the testimony of one of the founding members. I even asked the question. I had asked the question of Mr. Gonzalez, what was the intention of the parties? And there's an objection, says, no, there's no ambiguity in the document, and the judge sustained the objection. So if in fact there's an ambiguity here, what's the harm of going back to Judge Nielsen and permitting parole evidence as to what the party's intent was so that we can clarify that ambiguity? But if I might, we're through.
Well, the big
Down to 5 minutes, so proceed as you wish.
Go ahead.
Okay. And I can save the rest for rebuttal because I'm sure Mr. Elligott's gonna go in and argue about this exact provision. So I'll save the rest of my time for rebuttal.
Okay, Mr. Elligott, you need to unmute.
I believe I just did so. Can you hear me?
There you go.
Okay. Good morning, may it please the court. I'm Tom Elligott here on behalf of Kay Myers individually and as personal representative for Ms. Baker, who has passed away during the proceedings. As the court questions show, it knows there are two independent grounds to support Judge Nielsen's decision in the final judgment. And I know from a prior case that sometimes judges like to get a visual. There's a good map at page 964 of the record. If anybody wants to look back, and you'll see where Winthrop Way is and proceeds the property we're talking about. Ms. Baker's lot was at the northern, well, it wouldn't be the northern end, it'd be the western end. It'd be toward the top of the page where the water is. Now, I'm going to start where the court started, and that is the second independent ground, which is that the proposed use of the easement did not constitute an unreasonable use. And that's all that happened here. There was a proposal made saying, we'd like to do this. It was not met with warm enthusiasm, as noted. But that's all that happened. And if we look at first off, the agreement does not specify how the conduct is to be judged, so that a reasonable man standard applies. As in the case we've cited at page 10 of the answer brief, there is no contrary case cited in the reply brief. So we're looking at a reasonable man standard. But regardless of that, a proposed use isn't an actual use. The factual finding that Baker's use was not offensive or unreasonable is supported by the record. The easement, which is at page 980, gave the Bakers the right to use the road as if they were a lot owner. They paid $35,000 over the years for the right to use this road. This wasn't just a gimme. And again, it wasn't a use at all. There was a plan to build. It didn't come to fruition. And this is supported by the testimony of the president of the association, Ms. Tiller. Her testimony is in the transcript at 465 through 500. And you see her testifying, when you read her testimony in full, she's testifying the only basis for terminating was submitting the plan. She admits that the wedding got approved. That was not a big deal. She admits that association owners could put trash cans out and could have trucks use the road. She comes down to saying, she said Ms. Baker had put the trash cans out for 20 years and that was fine. What we have here, and I think it's also interesting that we learned from Mr. Gonzalez's testimony that the association waited over 20 months before terminating, putting the barrier up. So I guess it wasn't that offensive to them, even if you looked at it from their perspective. But in any event, what you see trying to happen here is they're trying in the reply brief and then this morning, they're trying to justify back and fill and come up with some justification. Well, why would this be offensive? And they refer to, the judgment said they're putting out the trash cans. The $164 fine, if you will, for putting out the trash cans was after the termination. In other words, once the barrier had been put up, the judge determined, well, you shouldn't have been putting the trash cans out. Even put aside that the termination was wrong, as he later found. But you can't have conduct after the termination be the justification for the termination. And then we see in the reply brief, they say, well, he used the wrong standard. You sort of heard that this morning. I think the word, he actually said it wasn't so egregious. That's a semantic argument. Not so egregious is the same as not so offensive. If the association thought that Judge Nielsen had used the wrong standard, then what it needed to do was to file a motion for rehearing and say, look, you used the wrong standard. They didn't do that. So again, Judge Nielsen's not wrong, and that argument's not preserved. I think the brief said you can't tell if he used a reasonable man standard. Well, I think it's apparent on a reading of the judgment, but again, they thought it was the wrong standard, moved for rehearing. So we have, in essence, a factual determination that there was nothing that warranted terminating, regardless of what the standard was, and regardless if you read the agreement the way the association wants to read it. That is supported by the record. That really is the end of the case from our perspective. I'll speak briefly to the easement. As noted, everybody agreed it was unambiguous. We then hear, well, maybe we did think it was ambiguous and we didn't win if you don't read it our way, then we think it's ambiguous. Well, the problem with that is that if there is an ambiguity, it is a patent ambiguity on the face of the document. Okay, and under Florida law, we don't get into parole testimony for patent ambiguities. We only do that for latent ambiguities. So even then, they still didn't get them to where they want to go. As far as the use by Baker, I mean, the agreement refers to use of the easement. Let me grab my. I had to map this out. Mr. Ruiz did send me back to the grammar books, as we see, but it refers to an easement granted by Baker. It doesn't say granted to Baker. There are several ways they could have done this to make it read the way they wanted to, and they didn't do any of them. They could have used commas in the right place. They could have done some other things. They didn't do it. And this so-called rule of grammar you're hearing so much about, we filed the very document that has been referred to as a supplemental authority. And yes, the first, when they had under the section 2 or more phrases, the first one says, well, there are some instances when you can flip phrases and it doesn't affect the meaning. But then they give the very next example is, no, there's some instances when it does. And they also point out that you can have a prepositional phrase modify another prepositional phrase, which was an argument that supposedly was against the rules of grammar as argued in the trial court, but it is in fact, indeed, in the very rule of grammar that they tried to rely on. For both these reasons, we would ask you to affirm. I'm happy to answer any questions or try to answer them if there are any questions. Whoops, I've lost you for some reason.
Thank you, Mr. Elegant.
Oh, pardon?
I said thank you, Mr. Elegant.
Okay, thank you.
Yeah, you're up, Mr. Ruiz.
Thank you. I'd like to go back to the revocation clause, if I might. And if the question is, what is it referring to? Which easement is it referring to? It begins by saying, upon default of payment of any fee. So that clearly applies to the easement being granted by the association to the Bakers. Then the question becomes when it says, or use of the easement herein granted by Baker in unreasonable or offensive manner. And that exact same phrase, as we argued, this refers to that exact same easement. But the exact same revocation clause was found in the license agreement from 1989, which is also in the record, which was also received in evidence in the trial. And that license agreement, there was nothing that the Bakers were giving at all. It was simply the association granting use to the road, the ramp, and the dock facilities, just like the easement that they're granting here. And yet it's word for word identical other than the use of the word license as opposed to use of the word easement. So you have an identical document that shows, well, what was the party's intent when they used this exact same language in the revocation clause? Well, it's referring to the same exact, the license that would have been granted by the license agreement is now the easement being granted by the association. There's no other
difference. The difference is, though, that the license agreement was one way and this agreement is two way, correct?
I'm sorry, I couldn't hear Your Honor.
The main difference, though, is the license agreement was just a one direction grant of a license, but the easement is, mutual or cross easements. And so doesn't that affect what the meaning of that language is?
Not at all. If you use the exact same words.
So you have to take that language in isolation and say, okay, because it used to be used in a one-way agreement, it means the exact same thing in this two-way agreement.
The language means what it meant in the one-way agreement. And if
that language is in a contract is always interpreted in light of the context and the entire agreement, correct?
Well, let's not extrapolate from this factual scenario a principle that we could try to apply to every case, because we know that cases.
Well, that is a principle that applies to every case. That's sort of a basic rule of construction, is it not?
Yes, but the idea here, and that's what the troubling issue is, that because somehow it's reciprocal in nature, we need to apply the rules differently. We need to interpret this differently. If this particular clause, the language means what it means, and it meant it in the license agreement, and it means it in this easement agreement. If in fact it was meant to apply to that concrete pad that Baker was giving the association, then it should have said that clearly, and it could have said that clearly with the addition of another sentence. But the way that this is drafted right now, this is referring to the easement that was granted by the association to Baker. And that's what this deals with, and that's the reading of this. And at the bare minimum, if what we're suggesting is we think this is clear on its face, the association thinks it's clear on its face, I'm sorry, the Myers and Bakers think it's clear on its face, we both have completely opposing views of what's clear on its face, then it must not be clear on its face, potentially, if we're both right under the rules of grammar and under the rules of construction. In which case, it absolutely makes sense for the court to listen to what the intent of the parties was. It absolutely makes sense for the court to consider the prior drafts, like the license agreement and the easement agreement, in reaching its ultimate determination. And the court did no such thing. And in fact, the court decided that the reading by the appellee was correct, but even if our reading was correct, he then applied an incorrect standard and used egregiousness, which is not found anywhere in the language of the revocation clause. And the revocation clause, to be clear, says automatic cessation. It doesn't refer to any decision by an arbiter or some objective standard. And the case that's being cited by Mr. Elligott's an employment law case. It's not an easement case with respect to what's the standard when the easement contract is silent. But at the end of the day, what we would suggest to the court is really that there's two alternative remedies. And either one, I think, would be appropriate depending on how this court wants to construe this document, which it can de novo. The first is that the court misconstrued the revocation clause, that our reading is correct, that the factual record that's before the judge, which he used to support injunction and money damages, is sufficient to allow the revocation by the association. The second is that there are competing correct views of this revocation clause, and that this should be remanded for the court to take evidence as to what the party's intent was, as we attempted to with sustained objections, or for the court to consider the other documents that were in evidence, such as the prior drafts. And we thank you for your attention this morning.
Thank you both very much. All right, our next case is Samsung SDI versus the Hildreths.